Welcome to channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your migration agent for the Australian visas. Now today I would like to take this opportunity in this video to discuss what is the actual criteria of the designated fund or investments under the subclass of 188 and commonly known as 188B for investor visa. Now if you don't have any ideas or whatever, I'll provide you a background of what this visa does. It basically gives a businessman or an investment professional investor or investment manager to actually access to this investor visa, whereby proof of your fund, source of your fund, and then subsequently injected into a government bond, a state government's bond. And while the bond has matured for the next 4 years, you will be eligible to apply for permanent residency. Now this visa is commonly used by a lot of applicants because they feel that the fund injected is safe, although it takes quite a while, 4 years to mature, but it's actually a very versatile and very safe investment. So today I would like to take you into a depth of this visa under the subclause 188.264. Yes, I believe it's 264. Basically talking about what designated investment is about, and I will move you into the actual policy and procedures to allow all the viewers and friends to actually know what should be prepared. So I won't spend too much, let's jump into it. So basically, now as you can see, this is the I take a lot of client into these manuals, and it's actually used by a lot of immigration professions. We have to subscribe into this so-called library. It's a massive chunk of law here, but I will take you step by step. So again, we are talking about 188.246, so clause 188.246. Now it basically talks about designated investment. So the law actually explain how the fund should be sourced and where to go to. So let me read it out for the actual law. It's quite simple. It's only about this much. I'll move it down a bit so you can read it properly as well. So number one, the applicant has made a designated investment. It's in blue. So once I click that, I can go into actual definition, but I'll take you to the policy and procedures of at least Australian dollars 1.5 million in a state or territory in which nominated state or territory government agency is located and has made the investment A, in the name of applicant, of course, don't make it in someone else's name, or in the name of applicant's spouse or de facto partners. So it's pretty obvious. Now number two, the sub point here is the fund used to make designated investment mentioned in subclause 1, which is this above, so 1.5 Aussie dollars, were unencumbered, meaning that it's not borrowed, it's not under any loan structures, and accumulated from either of the both, one or more qualifying business. So it can be accumulated from your business, conducted by applicant's spouse or de facto partner, or applicant's and his or her spouse and de facto partner. So basically accumulated by both or either you and your partner, together or either way. Okay. And number two, eligible investment activities of the applicant and applicant's spouse and de facto partner, or the applicant and his or her spouse and de facto partner together. So basically it says it can be a combination of business and investments earnings, or it can be solely just through your investments or through your business. Now this doesn't say too much about details. So what I have done is I got into the actual procedural manuals where this is what the case officer, immigration officers actually read through and follow through. So it's a very good digested extract for a lot of viewers or a lot of investors who are interested to migrate to Australia utilizing investment visa. Okay, so the intention of 1.246 to ensure the fund deposit into designated investments. So of course, so obviously it says the fund can be obviously through the law is accumulated from either you and your spouse or partner, and not accumulated through or from illegal activity. Illegal activities, basically they have some sort of stuff down here. So basically not sourced from eligible investment qualifying business activity, for example inherited or other windfall, or illegal activities. Basically it can be like gamblings, or selling drugs, and stolen funds. Fund is unnamed. Basically it's categorized as stolen funds, and the supporting document is not genuine, so it can't be handwritten A4 paper, so it can't be like that. So in assessing the ownership of the source of the fund, the case officer is looking into some of the details, how it has accumulated legally. So the ownership has to be under the applicant or applicant's spouse or partner. Okay, it's unencumbered, as I have explained it before, so there's no loan upon where the fund is actually coming from. Here we go, it explains that unencumbered, basically what it meant. Should consider where the fund will borrowed. Okay, so it can't be borrowed. Obviously that's categorized as a loan as well. So supporting documents, it will coming out from your SALP, which is the 11398 form, declaration state of your assets, and how you will liquidate your assets to become to have that fund of $1.5 million injected into the state or territory's bond. Okay, and obviously a resume will be very, very helpful, but this is very good to start with whatever the migration agent or whoever that you use. Having a resume explain what you have done and what business you're involved in and what investment you have been conducting with over the past years. It will be very, very helpful, very, very helpful. And what I usually do is I'll include that in the cover letter, so when the case officer pick up your file, they straight away understand how you have conducted investment or business, and likewise for the past years, and making sense of what the required documents is needed furthermore. Okay, and funding the designated investments, now this won't be too hard. It's basically how you will liquidate, which asset that you pick to liquidate, or if it's not declared in the SALP form, you can always nominate another one, but you have to prove that these funds or liquidated assets are legally acquired or accumulated over the years. So through my experience, generally the case officer will ask for a lot of taxation documents and order the financial statement if you do have a business, and the business can declare dividends and profits, income for the applicant as well. Now again, there are other ways, for example, inherited assets, so whether or not there's a will involved, the gift, when was the gift provided, and things like that, or a gift of shareholding in a company as well, and how that shares can be sold, or dividends share produced. So all these kind of stuff needs to be properly documented for sure, and if in the regions or country that you're in is required to be taxed, then these taxation documentation will then require to be provided as well. So in my general practice, I'll basically ask for client at least about 5 to 7 years of their taxation paperworks, individuals, families, and also the company or business or investment company if they do have investment companies, and this will straight away demonstrate how the funds are legally acquired. And now as long as that's been done, That's all it is required. Now there are clients ask me whether they could just unsell their property and liquidate it into cash. Well, it's good, but the only issue is here is you can't wait until the visa applications or the case officer actually asks you to actually invest inject the designated investment into the bond, and then at that point in time you're trying to sell your house, and then as you know, in common sense, you can't sell a house within a day. It has to go for a while, and with getting to contract and things like that, so it's not that easy. Now if you do have that concern and that's what you want to do, plan ahead. Okay, plan ahead and get, and of course once you sell the property and liquidate it into cash into your bank account, put that all supporting evidence all together. So once we hit that point of time required to get the designated investment into the actual state or territory bond, you will have all that paperwork documented already and forward onto the immigration. Now finally, once that's all done, the final step obviously is injected money into the actual bond. So a form 1031 is required to be completed. So generally the immigration officer will get that predominantly most of the form completed, with only left the I think it's page 3 or somewhere. That's all for your personal identifier ID stuff. You put it in there and get the final stamps and signatures. Once that's all done, a trace of fund is required. So which bank account would that fund go through and get into the actual the state or territory bond, and then the whole procedure will be completed. Anyway, investment visa is not an easy go. It's quite complicated. So if you do have any comments or questions, feel more than welcome to write to me. Leave it to the comment below, and I'll answer you and respond to you in timely manner. Now obviously if you do like our videos, should consider to subscribe to our YouTube channel. I noticed that there are more and more viewers require more of English explanation about all type of different visas, so I'm planning to produce more English videos, and then you can share around. Anyway, I see you for next video. Goodbye.